Hello and welcome to Byju's Exam Prep IAS. Let's get started and look into our daily quiz. Before we start with our today's practice questions, a quick gentle reminder. Byju's Exam Prep IAS has already launched its official Telegram channel. What is that you have to do? Follow the link given in the description box or scan this QR code. This will take you to our official Telegram channel. Join the channel so that you get all the current affairs related updates. Let's get started and look into the first question. Consider the following statement. A municipality reconstituted after premature dissolution does not enjoy the full period of 5 years but remains in office only for the remainder of the period. The constitution prescribes reservation of seats for SC, ST, OBC and women in the municipality. Which of the statements given above are correct? The answer to this is one only. Why have we taken this practice question? Because this article on the Hindu makes a reference to Bengaluru civic polls. Let us try and understand what are these statements. When you look into the first statement, it says a municipality reconstituted after the premature dissolution does not enjoy the full period of 5 years but remains in office only for the remainder of the period. What do we mean by it? Whenever it is constituted, it remains in office for a period of 5 years. But what if there is a dissolution? In that case, if the dissolution happens after 2 years, they will remain in office for the next 3 years and not again for the 5 years. This is what is the first statement. So the first statement is right. When you look into the second statement, the constitution prescribes reservation of seats for SC, ST and women and it is not the OBC. So when you look into article 243T, it speaks about reservation of seats. It speaks about scheduled castes. It speaks about scheduled tribes. It also speaks about women as well. But do note, it only says nothing in this part shall prevent the legislature of a state from making any provision for reservation of seats in any municipality or offices of chairpersons in the municipalities in favor of the backward classes of the citizens. The constitution does not prescribe. It leaves it to the state legislature. The state legislature can come up with their own law and they can reserve the seats for the OBCs, that is the backward community. So remember, the constitution only gives it for the scheduled castes, it gives it for the scheduled tribes as well as for the women. It is not for the backward classes. Constitution says you, the state government, decide. You pass a law. If there is a law permitting reservation for the backward classes, they would be able to do, which is why the second statement is wrong. It is not given for the OBC under the constitution. The state may come up with its own law. Now let's look into the next practice question. Consider the following pairs. We have the security force on one side, the border that it guards on the other side. Border security force, Pakistan and Bangladesh, ITBP, Nepal, Sashastra Seema Bal, China, Assam Rifles, Indo-Myanmar. How many pairs given above are not correctly matched? The answer to this is only 2 pairs. Why have we taken this practice question? Because this article on the Hindu makes a reference to Sahastra Seema Bal. Let us try and understand what are these statements. When you look into the first one, what we have is the border security force. Yes, the border security force guard India along the borders of Pakistan and Bangladesh. First statement is right. When you look into Assam Rifles, yes, they do guard the borders of India along the Indo-Myanmar borders. But when it comes to ITBP, it is not Nepal, but instead it is China. When it comes to Sahastra Seema Bal, it is not China, but instead it is Nepal. This question is asking for not correctly matched, so it is only 2 pairs. Now let's look into some of the key facts with respect to these security forces. When we speak about Assam Rifles, the Assam Rifles was established in 1835. It is considered the oldest of all paramilitary forces. This force plays a crucial role in northeast India, handling counter-insurgency and border security operations. They are also guarding 1643 kilometer long Indo-Myanmar border since 2002. Then we have the border security force. It is the border guards of the country and is called the India's first line of defense. The union government agency under the administrative control of Ministry of Home Affairs came into being in the wake of 1965 Indo-Pakistan War. It was established on 1st of December 1965. If you are a student of public administration, there have been questions in the past where they have asked you different security groups as well. So remember, under the Central Armed Police Forces, we have Assam Rifles, Border Security Security Force, Central Industrial Security Force, Central Reserve Police Force, Indo-Tibetan Border Police, National Security Guard, and Sahastra Seema Bal. They've asked questions in the past, so this can also be asked in your mains answer writing as well. Now, if you look into the other forces, we have the Indo-Tibetan Border Police. The Indo-Tibetan Border Police, or the ITBP, was established on 24th October 1962. It was created under the CRPF Act, and it guards the Indo-Tibetan border and the mountainous regions of India-China border and monitors the northern borders. Then we have the Sahastra Seema Bal. It was set up in March 1963. They guard the Indo-Nepal as well as the Indo-Bhutan borders. Please remember, this can be very important from the prelims as well as the mains examination point of view. Now let's look into the next practice question. With respect to Dada Saheb Phalke Award, which of the following statements are correct? It is India's highest award in the field of cinema. It is presented annually at the National Film Award ceremony by the Directorate of Film Festivals. The first recipient of the award was actress Devika Rani. As of 2022, only 2 recipients have received the award posthumously. Which of the statements are correct? The answer to this is 1, 2, 3, and 4. Why have we taken this practice question? Because this article on the Hindu makes a reference to Dada Saheb Phalke Award. So remember, we have President Draupadi Murmu, who gave away the National Film Awards for the year 2020 under various categories at the 68th edition of the ceremony. The Dada Saheb Phalke Award was conferred on veteran actor Asha Parekh. This can be important from the preliminary examination point of view. So this happens to be India's highest award. It is presented annually as well. First time this was presented back in the year 1969. The award was introduced by the Government of India basically to remember and cherish the memories of some of the great individuals who have contributed to the Indian cinema. Yes, the first recipient of the award happens to be actress Devika Rani, and as of 2022, yes, only 2 recipients have received the award posthumously. As part of the assignment, you have to put on the comment section who are these 2 individuals who have received the award posthumously. Please put it on the comment section. Now let's look into the next practice question. What is preliminary prospectus in an IPO process called as? Articles of Association, Memorandum of Association, Red Hearing, Underwriting. The answer to this is Red Hearing. Why have we taken this practice question? Because this article on the Hindu makes a reference to the initial public offering. What is this initial public offering? Let's say, for example, there is one of the company. This happens to be a private company. So most of the investments are made by the family and friends. You also have few professional investors like the venture capitalists and angel investors. This particular company may not have gone public. So for the first time, when a company offers its stock for sale to the public, is what is called as the initial public offering. So when the company goes on a public platform, it registers with SEBI and asks people for the money for the first time. That is called as the initial public offering. Then we have something called as the red herring prospectus. What is it? This happens to be the preliminary document. It is that particular document which gives us an idea about the company's business operations, who are the promoters, what are the financial history of that particular company. The document also clarifies why the company wants to raise money from the public, how the money will be used, the risks associated. All of this will be provided in what is called as the red herring prospectus. So remember, IPO is the first time that a company goes public. It is taking money from the public and it will release what is called as the red herring prospectus. It is a document which gives an entire perspective about the company's operations. Now let's look into the next practice question. In the northern hemisphere, the longest day of the year normally occurs in the first half of the month of June, second half of the month of June, first half of the month of July, second half of the month of July. The answer to this is second half of the month of June. This happens to be a previous year question from the year 2022. Now let's look into the fact of the day. The fact of the day for today's discussion is preventive detention. Let us try and understand what is this concept of preventive detention. There are two types of detention. One is what is called as the punitive detention. The other is what is called as preventive detention. What is this punitive detention? Let's say there is a person who's committed an act. This happens to be an illegal act. So the court looks into this entire case. Trial is also on. Prosecution is able to prove its charges as well. And ultimately, this so-called accused will become culpable, and when a person is punished, that is what is called as punitive punishment. So basically, when a person is punished and he is thrown behind bars, that is what is called as punitive detention. But there is something called as preventive detention. In this case, the person may not have committed an illegal act, and at the same time, the executive feels that this person in the near future may commit an illegal act. As of now, he has not committed it. In the near future, he may commit it. So taking this person and keeping it under the custody of the executive for a brief period of time is what is called as preventive detention. In punitive detention, the person has already committed an illegal act, but in preventive detention, he is not committed, but there is a fear, there is an apprehension that person may commit an illegal act, which is why he is detained under preventive detention. If we look into the history pages in India, the history of preventive detention dates back to the early days of British rule, when under the Bengal Regulation 3 of 1818, the government was empowered to detain anybody on mere suspension. There was also Rule 26 of the rules framed under the Defence of India Act of 1939, a wartime legislation which allowed the detention of a person if it was satisfied with respect to that particular person that such detention was necessary to prevent him from acting in any manner prejudicial to the defense and safety of the country. Who can make laws under the preventive detention? When you consider union list, you have an entry item 9, which is preventive detention for reasons connected with defense, foreign affairs, or the security of India, persons subjected to such detention. So it is the central government which would be able to make laws under entry 9. So if the central government decides, they can come up with an own law with respect to defense, foreign affairs, or security of India. Then we have the concurrent list. It speaks about entry item 3, preventive detention for reasons connected with the security of a state, maintenance of public order, or the maintenance of supplies and service essential to the community, persons subjected to such detention. So the state government can also make the laws, the central government can also make the laws, because it is in the concurrent list. So who can make laws? The central government can make the laws, but with respect to defense, foreign affairs, or security of India, and concurrent list, the central government and state government both can make the laws as well. Now, if we speak about this idea of preventive detention, what has the Supreme Court said? Is it constitutional? Is it constitutional for preventive detention to be still continuing in the Constitution of India? What has the Supreme Court said? The Supreme Court said in Ankul Chandra Pradhan versus Union of India in 1997, the object of preventive detention is not to punish but to intercept the prevent the detainee from doing something prejudicial to the state. The satisfaction of the concerned authority is a subjective satisfaction in such a manner. So the Supreme Court has clarified that this provision that is present under the Constitution is a constitutional premise. The executive, to prevent any illegal activities that may occur in the near future, can make use of preventive detention, says the Supreme Court of India. In this case, the article goes on to say that preventive detention is a serious invasion of personal liberty. You can go ahead and make sure that this person is prevented from committing an illegal act, but if due process is not conducted, if this person is detained, it is also preventing that person from exercising his liberty. So the Supreme Court has referred to the landmark judgment of Ashok Kumar versus Delhi administration, where it has said preventive detention is devised to afford protection to the society. The object is not to punish a man for having done something, but to intercept before he does it and to prevent him from doing it. And added, in view of the above object of the preventive detention, it becomes very imperative on the part of the detaining authority as well as the executing authorities to remain vigilant and keep their eyes skinned but not to turn a blind eye in passing the detention order at the earliest from the date of the proposal and executing the detention order, because any indifferent attitude on the part of the detaining authority or executing authority would defeat the very purpose of preventive action and turn the detention order as a dead letter and frustrate the entire proceedings. So this article in the Indian Express clearly goes on to point out that the Supreme Court has clarified that you can go ahead with the preventive detention, but this has to follow the due process, says this article. It is this that we have to understand with respect to this article. So this is it for today. Thank you for watching. All the best.